Hello, I am Rusha Mukherjee, a student of Surendranath Law College, presently interning at LEXCLIQ. Today I am going to talk about Article 22 of the Constitution, which is a very important provision of the Constitution. In Article 22, we talk about punitive as well as preventive detention. It talks about the arrest of persons. Before we get deep into the section, we will talk about what is arrest in very simple words. Arrest is when somebody is taken into custody and that person is actually deprived of the basic rights, basic liberties. Not rights but basic liberties, and much of it is restrained when that person is under custody. Now, coming to the fact that Article 22 talks about both preventive and punitive detention. Now, Article 22, Clause 1 and 2 talks about punitive detention. Article 22, Clause 3 talks about the exceptions, whereas Article 22, Clause 4 to 7 talks about the preventive detention. Now, we will know the difference between preventive detention and punitive. Punitive is when the work or the act or the offence has been done and the arrest or the detention is as a result of that act or that offence that has been committed. It is a punishment for the offence that has been committed. However, in the case of preventive detention, the offence has not yet been committed, but the detainee or the person who is being detained has a potential to commit that offence. And for the safeguard of the entire public, that person is required to be detained. Second point of difference is punitive detention can be done under ordinary laws. However, the preventive detention requires special preventive detention laws. All the democratic countries across the country do not have a preventive detention clause or provisions in normal conditions. But India is the only democratic country that has incorporated preventive clauses or preventive detention clauses in the Constitution that is applicable throughout the year, even in normal conditions. In other countries that are democratic, these preventive clauses can only be operational during the time of emergency. Now, when we come to know about these differences between the preventive detention and the punitive detention, we will step into Article 22, Clause 1. Article 22, Clause 1 gives the person the right to be informed of the grounds of arrest and also the right to consult a practitioner. Article 22, Clause 2 gives the right to the person to be produced before a magistrate within 24 hours of his arrest. If the time period of 24 hours has lapsed, that person is entitled to be freed. The 24 hours can be exceeded only in case of judicial custody. However, we can see that the time period of 24 hours do not include the time of emergency or the time of travel. Preventive rules, so the preventive rules was not introduced by the constitutional makers for the first time. It was introduced by the British, and these were in the acts of the Bengal Regulation Act and some other acts as we see. India wanted to incorporate these type of preventive detention clauses with some safeguards with it. Both the central and the state government has the power to make laws. The central has the power under Schedule 7, List 1 to make exclusive rules or exclusive laws relating to defense, foreign affairs and the security of the state. However, the state is given concurrent power to make preventive laws under Schedule 1, List 3 regarding the maintenance of public order, security of the state, and the maintenance of the essentials. The cases of preventive detention is being heard by an advisory committee, and any person who has to be detained for more than 3 months has to be detained with the permission of the advisory board. The procedure with which the advisory board will work and all the other particulars are given in the article itself. Article 22 clause 5 gives the detainee who has been detained under the preventive clauses the right to be informed and also the right to be represented. However, Article 22 clause 6 says that if disclosing of the facts is against the public interest and is may pose a threat to the public at large, then the authorities are not compelled or not obliged to disclose such facts. Article 22 has a very close relation and has to be thought in the light of Article 21 always, because of the fact that Article 22, specifically the preventive clauses, is aiming at curtailing the liberty of the persons who is being detained. And hence, we have given a very short idea about the difference between the punitive arrest and the preventive arrest, and what are the safeguards and the ways that is prescribed under Article 22 of the Indian Constitution. However, Article 22 of the Indian Constitution never deals with civil arrest. For example, if a person is arrested for not giving their taxes, that arrest will not come under the constitutional framework of Article 22. Thank you. Have a nice day.